morning, ladies and gentlemen. This morning, we're going to have a special webinar for more than 120 businessmen and HR managers for establishments located in Muntinlupa, Parañaque, and Las Piñas under the umbrella of the Philippine Chamber of Commerce and Industry Muntinlupa chapter with Ms. L.B. Sanchez Quiazon as the convener and the president of the chamber. We are going to discuss three topics. One is the anti-terrorism law of 2020. Number two, the DOLE advisories on labor and HR. And number three is employee discipline under the new normal. To all of you, good morning, especially to the President and to our guest, Ms. Delia Jimenez, and to you, and to Attorney Pabros from Pepsi-Cola. Thank you for that very nice introduction. And just to clarify, instead of one topic today, I am giving you three topics, but I will manage time to make sure that there will be a question and answer portion. So this is 3 in 1. We will talk about the DOLE advisory, especially that there is an ongoing confusion today whether it should be the employer who should pay for COVID testing. We talked to Secretary Bebot Bello, who is our good friend, and also the DTI Secretary this morning clarified on TV the confusion on testing of all employees charged to the employer. So there is a very serious concern among the businessmen, especially the small scale and the medium scale industries, to be able to afford the COVID testing for all employees. So I will be going to clarify that together with other DOLE advisory. So all of you, please prepare your question. I will make sure that I'll make this snappy so that you will have a lot of time to ask questions. Then I consider it important that you should all know about the anti-terror law, because it is possible that some of your employees may be arrested for suspicion of being a terrorist. You, the managers, and especially the HR practitioners, should be able to answer questions about the anti-terror law. And we have the usual problems about employee discipline and dismissal under the new normal. There's a lot of questions. Attorney, are we going to dismiss an employee who refused to return to work despite the fact that we provide transportation? And is it possible that we should charge him of insubordination or gross and habitual neglect of duty? I'll clarify all this. No, I hope that Attorney Pabros will help me, being a good lawyer and an HR practitioner also, and we can answer the question together. We will have an official answer that will be adopted by all HR professionals in Muntinlupa, even in Parañaque and in Las Piñas. No? There are 4 areas of responsibility in managing people. Kayong lahat na nakikinig sa akin, whether you are in HR or in business management, you look at the 4 dimensions of people management. One is talent acquisition, and that is recruitment of the best talent. Number 2 is total rewards, which includes salaries and benefits, compensation. The third one is used to be called employer relations, labor relations, and industrial relations. There is a difference among the three. Kayong mga nakikinig, pag gumamit kayo ng salitang ER, LR at saka IR, merong kaibahan yan. Mamaya sa question and answer, if you want to clarify that, you can ask that question. Now we are calling it organizational justice. Pillar of employee discipline and the pillar of grievance handling. Employee discipline, we make sure that our people behave according to the expectations of management. Grievance management, we make sure that management listens and addresses properly the grievances of the employees. So it is two-sided, it's not one-sided. And then training is now learning and development. So the four, if you want to master HR, you must master the four. Talent acquisition, total rewards, organizational justice, and learning and development. And today we have to comply with labor laws, but we have to preserve our business. Because if we destroy our business, there is no more employer, and the employees will also lose their job. So it is important that the role of PCCI in Muntinlupa is to preserve business, but not neglect the rights of the workers, the health, safety, and welfare of our employees. And therefore, always we are advocates of balance in management of our people, because we are in an era of disruptions. Now, I will repeat what I have been talking since 1990 when I was with Pepsi Cola. The relationship with employer and employee is like husband and wife, and the Department of Labor is the mother-in-law. Ano bang papel ng mother-in-law sa buhay ninyo? Ang papel ng mother-in-law ay pakikialam. So ang gobyerno talaga ay nakikialam sa mga employer and employee. That is the reason for the existence of government. To make sure that the DOLE makes pakialam about salaries and wages, about safety, because it has something to do with the mandate of the government to afford protection to labor. So huwag kayong magalit sa DOLE kasi ang DOLE is doing its job. Para silang mga biyena na nakikialam. Wala namang problema sana ang employer and employee. Dumating yung biyenan, nagkaroon ng problema. So, yung problema na yan ay dapat harapin natin na may karangalan, with honor and with dignity. Huwag tayong tumaka sa problema, harapin natin at makipag-usap tayo sa mga manggagawa dahil partner naman natin ang manggagawa, hindi naman natin kalaban. No? So, dapat ganun ang maging attitude natin na balanse ang ating paningin. So, we will now start with the DOLE advisory. The reason why the government gives power to the DOLE is because of the provision of Article 5 of the Labor Code. No? The Labor Code of the Philippines, which was passed in 1974 during martial law. Di ka pa isinilang yan, Marvin. Noong 1974, I was already a lawyer and I was part of the OPLE boys. Mga batang-batang mga abogado, kinuha kami ni Secretary OPLE. Sabi niya, yung mga dating mga aktivista tulad ko na nabilanggo, na detain noong panahon ng martial law, dahil sa aming pagka-aktivista, kinuha kami ni Secretary OPLE dahil siya din naman ay isang aktivista at kami ang gumagawa ng mga rules and regulations implementing the labor code. He utilized the idealism of the young lawyers to become instrument of justice. At kaya kami napasok sa DOLE at the very young age of 24. I was a very young lawyer. I joined the Department of Labor. And then I left. I went to the private sector. I went to Petron, to San Miguel, and then to Pepsi-Cola, and then came back as Undersecretary of the Department of Labor. Yun ang story ng buhay ko, no? So, ako lang siguro ang tao na merong experience bilang manggagawa dahil labor leader din naman ako sa Cebu nung ako'y aktivista pa. Then pagkatapos na punta ako sa gobyerno, from government I went to management. So tatlo ang experience ko, Mr. Marvin. Tatlo. From labor to government to management. So may karapatan ako mag-advise dahil nga rounded ang aking experience, well-rounded, no? Yan, alam ni Ate Delia yan kasi kabarkada ko yan dyan sa Alabang at kami yung nagbibigay ng advice sa mga maliliit na mga negosyo noong araw. 1991 pa yun eh. Dalaga pa si Delia Jimenez noon eh. No? Mukhang dalaga lang. So, because of Article 5 of the Labor Code, ay nagkaroon ng kapangyarihan ang DOLE Secretary to issue rules and regulations, department order, na merong force of law. So pag department order, like Department Order 174 about labor contracting, job contracting, yan ay may force of law. Pero pag advisory lang, tandaan nyo iba yung department order sa labor advisory. Kasi ang advisory is just a suggestion. It has a persuasive effect, but it has no mandatory effect. In other words, wala kang penalty kung hindi ka sumunod dyan, no? Magagalit lang sa iyo ang mga taga-DOLE kasi hindi ka cooperative. Pero in the eyes of the law, you have not violated any law. Okay, so mag-umpisa tayo sa Labor Advisory number 20. At yan ay hindi na natin i-discuss kasi it is just about how to compute your wages or salary for June 12, which was the Independence Day. So we should not waste our time on that. Labor Advisory 21 is guideline on the qualification of public and private health workers. Kung kayo mag-hire ng nurses, kasi required tayo na may mga nurse, depende sa number of employees. If you look at Department Order 198, implementing Book 4 of the Labor Code, merong table doon how many employees, how many nurse, how many company physician, part-time or full-time, depende sa number of employees. Pero sa mga small scale, hindi na kailangan lang natin mag-tie up with the nearest public health clinic or private hospital to provide services for our people in case of emergency. But if you need to hire a nurse, there is a guideline and that is Labor Advisory 21. So there are protocols and there are compensation. There is suggested salary level for nurses, no? Especially ngayon, napakahirap ngayon ang mga nurses because sa need ng pandemic ay nagkakaubusan na tayo ng mga frontliner. So, dapat alagaan ang terms and conditions of employment of nurses. Sa Labor Advisory number 20, Hindi rin natin dapat pagtuunan ng maraming panahon ito kasi this is just a computation of wages on Eid al-Fitr, the end of Ramadan, which is May 25, no? And that is very clear that Eid al-Fitr is a regular holiday. Ang regular holiday ay kung hindi mo pagtatrabahoan ay yan ay bigyan mo ng 100% ang empleyado mo pag hindi nagtrabaho. Pero kung pinatrabaho mo on that holiday, 200% ang ibigay mo. And that is very elementary, basic. Lahat ng mga employer nakakaalam na niyan, no? So sa 19 naman, this only apply to POGO, Philippine Offshore Gaming Operations. Hindi naman kayo mga POGO, so hindi na natin i-discuss yung 19. Yung 18 is prevention and control of COVID-19. So dapat natin itong i-discuss kasi importante ito eh. Employer daw should shoulder the cost of COVID-19 prevention and control. So ano-ano ito? Yung mga mask, yung mga alcohol, yung mga paghuhugas every now and then. Well, the most employers can afford that, no? Ngayon nadagdagan na ng shield aside from mask. So if we follow the spirit of Labor Advisory number 18, ang employer pa rin ang magbabayad ng shield, no? Pero ngayon ang DTI nagbibigay na ng suggested retail price kasi maraming take advantage ditong panahon ng emergency. Nagbebenta online ng mga matataas na presyo ng shield, no? Pero ang mga Pilipino are very creative. They can create their own shield. There are even tribes in Mindanao who are creating shields by the use of bamboo, no? At dapat suportahan niya ng Chamber of Commerce and Industry kasi mga indigenous people yan na gumagawa ng paraan through the creativity and ingenuity of the Filipino na kawayan yung kanilang shield, no? So ito lang ang importante dito. The regional offices shall provide assistance to companies who wants to comply. So kayong mga employer dito sa tinatawag na Montaparlas, Muntinlupa, Taguig, Parañaque, and Las Piñas, meron naman tayong labor office nandoon sa Las Piñas. You have to have a very strong link with that office. Huwag kayong pumunta sa Dole kung hinahabla na kayo ng taon nyo. Dapat makipagkaibigan kayo sa Dole dahil sila naman ay tutulong. And if you have problem with them, because they are my friends, I was their superior before, they know me, at may problema kayo, lapitan nyo ako, tawagan nyo ako, at tutulungan ko kayo na masusolve ang problema ninyo. Yan ang ginagawa ni Ma'am LB Quezon, na siya ang nagiging tulay para matulungan natin ang mga small and medium scale. Yung mga malalaking kumpanya tulad ng Pepsi Cola, mayayaman yan eh, may sariling mga abogado yan. Nandyan si Atty. Pablos, hindi na kailangan na tulungan yan. Sila yung tutulong sa atin dahil marami silang means, no? At when I was with Pepsi Cola, I really helped a lot sa panahon ni Miss Delia na siya namumuno dito sa Muntinlupa Chamber of Commerce and Industry. At napakaganda ang teamwork ng Chamber at ni Mayor Presnedi. Kasi si Mayor Presnedi, napaka-bait both to labor and management at napakadaling lapitan. Yan ang magaling na mayor eh. Mahirap yan na mahirap ng tularan yan si Mayor Presnedi, no? Okay, so yan lang sa Advisory 17. Sa 18 naman, ito yung mga paraan how to preserve and to facilitate the resumption of business operation. And dito sinasuggest ang mga iba-ibang working schemes, no, like work from home, like compressed work week, yung blended yung physical appearance at saka work from home. Napakaraming paraan. For instance, itong mga options ng management. You can transfer employees from one branch to another. Ang konsiderasyon dito is not only the business imperatives but also the safety and the health of the employees and their accessibility. Kasi kung sobrang layo, taga Caloocan ka, tapos nagtatrabaho ka sa Alabang, napakahirap yan. Kung ikaw, taga Batangas ka, tapos nagtatrabaho ka sa Alabang. So, dapat we have to think of job rotation with yung multi-skilling, yung kung ikaw ay dati, ang trabaho mo ay talagang pang-factory, kung maaari kang bigyan ng trabahong work from home because you are either pregnant woman or you are a senior citizen or you are a PWD, yung mga employees with history of medical problems, bibigyan ka ng pagkakataon na magtatrabaho ka at home, no? And if you work from home, your output should be clearly defined because it's very difficult to monitor your actual performance. Considering that you are at home and the employer, the supervisors and the managers are in the office, how to facilitate supervision? This time, instead of focusing on the number of hours, we should consider, for instance, output-based. You will be paid based on result, on output that are predetermined, with specific and measurable and time-bound. And you will be paid fairly with the assistance of Dole Regional Office pag merong tinatawag na time and motion study, no? Number 16, ito yung alien employment permit, hindi applicable sa inyo except if you are employing foreign workers, no? Payment for May 1, we will skip that. Clarification of non-inclusion of 1 month. Maraming nagtatanong sa akin tungkol sa probationary period. Kasi if you hire an employee in January and he is under probationary period, by June 30, if we were in a normal situation, and if he was able to pass the reasonable standards that are made known to him at the time of the engagement, then by July 1, he should have already attained a permanent status. Tandaan nyo ito mga kasama, yung mga words natin, ayusin natin. Huwag niyong sabihin na ang empleyadong nakapasa sa probationary period ay regular na. Mali yan eh. Ang kanyang posisyon ang regular, siya ay probationary. Pag nakapasa siya ng probationary, hindi siya naging regular, nagiging permanent siya. Kasi ang tao hindi regular, ang posisyon ang regular. Ang tao ay probationary or temporary, then he becomes permanent. The status is temporary, but the position is regular. Take note, tingnan ninyo yung definition ng regular employment sa Book 6 at saka itong sa Book 3. Yung ginagamit dito sa Book 3, yung definition ng labor-only contracting, yung tinatawag na directly related to the business of the principal. Tandaan nyo kayong mga nagmamanage ng tao, hanggang ngayon nako-confuse kayo. Makinig kayo sa akin kasi sa tanda ko na ito at saka sinusulat ko na ito at ina-argue ko na ito sa Supreme Court. Ito yung malinaw. When you talk of position, regular or casual, pagka regular, how do you know that a position is regular? The best evidence that a position is regular is if it is found in the table of organization. Why? Because that has been approved by the board of directors. The HR person cannot create a position. The HR, even if you are an HR director, you cannot create a position. You will just fill up a position. So the position, the job of creating a position, which is an amendment of the table of organization, is the job of the board of directors. Now, once the position is created and it is vacant, and there is a rectangle, there is a square or a rectangle in the table of organization, that is a regular position because it means that such a position is directly related to the main business of the employer under Book 3. Under Book 6, that position is necessary or desirable to the usual business of the employer. Tandaan niyo yan dalawa yan sa Book 3 at saka sa Book 6. Ngayon, ang posisyon ang regular. Ang tao, hindi regular. Ang tao, nag-apply pa, inadmit mo, probationary. Pagka nakapasa sa probationary period, ay magiging permanent. So, mali yung mga ginagawa ninyong memo at statement na the employees should now be regularized. You cannot regularize an employee because he has never been abnormal. So, the employee, the status of the employment is now made permanent from probationary. It is the status that is elevated to permanent. But the position is regular, even if the incumbent is only probationary. Maaari din na ang posisyon, for instance, posisyon ng HR assistant ni Atty. Pabros na pregnant, buntis. So, ang posisyon niya regular, pero pag nabuntis, nag-maternity leave, ngayon 105 days na ang maternity leave. So si Atty. Pablos, mag-hire siya ng replacement. Yung replacement is temporary in status, but the position is regular. Because the moment the permanent HR assistant is reinstated from maternity leave, that temporary has no claim over that job, even if she has been replacing all the pregnant employees and she has already accumulated more than 1 year. Hindi pa rin siya magiging permanent because she is just a temporary replacement of permanent employees occupying a regular function. So I had to explain that because I am quite sad that until now, even HR people are not clear about that. Ang mga HR natin, nako-confuse pa rin kung ano bang kaibahan ng regular sa permanent. Basta tandaan nyo, ang posisyon ang regular. Ang status ng incumbent ay temporary or provisionary na nagiging permanent. Yun, malinaw tayo Ang sinabi sa Labor Advisory number 14, dahil nga naman dahil ang employer ay walang sapat na pagkakataon na maobserbahan ang fitness ng isang probationary employee because we were interrupted by the COVID crisis. Puputulin muna yung pagbilang ng 6 months at i-resume yan pag bumalik na tayo sa new normal. Ang tanong, kailan ba tayo babalik sa new normal? Merong mga pagkakataon hindi nilinaw ng DOLE ito. Ang new normal ba pag JCQ? Ibalik na ba namin? Yan ang problema ng DOLE kasi gumawa sila ng labor advisory na hindi nila nililinaw. Kailan ba namin i-resume uli ang pagbilang ng 6 months? Ang sagot ko ganyan, ganito. Pag bumalik na ang pagkakataon na ang empleyado ay maoobserbahan na ng employer talaga as to his fitness and to his compliance with the standards that are made known to him at the time of engagement. Isa pa ang gusto kong linawin sa inyo, mga kasama, huwag kayong magalit sa akin kung makulit ako. Kasi bilang professor, makulit talaga ako kasi alam ko yung mga estudyante ko, kunwari naintindihan nila kasi nahiya sila magtanong. Pero ako, ina-assume ko hindi nila naintindihan. So, ganito yan. Pag hinire mo ang isang probationary employee, i-attach mo sa kanyang job offer yung listahan ng standards. Kaya natatalo ang kaso eh. Natatalo ang kaso. Alam mo dyan sa Enchanted Kingdom, sa Laguna, yan ang leading case eh. Kasi yung hinire nilang isang engineer, hindi nila binigyan ng reasonable standards. So, pagdating ng 6 months, sinabi, hindi ka pumasa sa iyong mga, you cannot qualify to attain a permanent status. So ang tinanong ngayon, what was the standards that you used in determining why I did not pass? Madali lang sasabihin na hindi ka nakapasa, pero kailangan ipaliwanag mo dahil ikaw, employer, you have the burden of proof pag pinailang ka ng illegal dismissal cases. Patunayan mo ngayon, did you furnish the employee? Ang sinabi pa naman ng batas, napakahigpit. On the first day of the engagement, hindi kinabukasan. Pag dinyab offer mo siya, sabihin mo, probationary ka, pero i-evaluate kita. I will evaluate you 3 times. Alam mo, Attorney Pablos, ang suggestion ko dyan, pag hire ang position, halimbawa supervisory up to managerial, dapat 3 evaluation eh. End of 1st month, end of 3rd month, and end of 5th month. 3. Tapos sa 3 evaluation na yan, kailangan pumasa siya ng at least 2 out of 3. At doon sa libro ko, yung HR Form 101, nandoon na lahat ng standard, nandoon na yung value, ano ang value ng competence, ano ang value ng character, ano ang value ng customer orientation. Lahat yun eh, competence, character, customer orientation, conscientiousness, commitment, nandoon lahat. Tapos, bigyan mo ng scale, 0 to 10. Mag-evaluate hindi lang HR, kundi yung direct superior niya. Tapos, end of 1st month, hindi siya pumasa. 2nd month, napapasa na siya. Dapat ipasa niya yung 3rd evaluation para magiging permanent siya. Ganon din yan. Dapat, Ms. Delia, isasuggest ko na yung mga mag-aasawa, meron ding probationary period eh. Yung pag ikaw mag-asawa ka, 6 months, i-evaluate ka ng misis mo o ng mister mo. At saka merong reasonable standard. So pwedeng after 6 months, hindi ma-regularize yung husband mo. Instead na mag-divorce tayo, instead na mag-annulment tayo, ay magiging regular status ng marriage after 6 months. So this advisory is just to have something to bridge between the new normal and the old normal, which until now cannot be perceived in the immediate horizon. My prediction is we will continue to have this system until January. So we will have a very austere Christmas and very unpredictable New Year. Sa tingin ko lang malungkot ang Pasko natin ngayon. Matuto tayong mamaluktot kasi maiksi ang ating kumot. No? Supplemental guidelines to the remedial measures. Ito yung advisory term, no? And I have discussed some of them already. Itong 9, importante ito kasi ito yung sa flexible work arrangement. At sa flexible work arrangement, there are 4 I am suggesting and also based on this advisory. Number 1, status quo as is. Report to the office with the assistance of management. In Laguna, many of the establishment doon na natutulog at nag-i-stay mga workers sa factory. Ang problema lang sa Laguna ay very high ngayon ang infection rate. So napakahirap nila na mag-usad sa more liberal quarantine system. So isang alternative is stay in the office, provide board and lodging for the workers. Yan, yung maka-afford. Pangalawa, yung work from home. Pangatlo, yung compressed work week. Compressed work week, ang ibig sabihin, magtrabaho pa rin kayo ng 48 hours per week, pero gawin na lang natin na halimbawa na 4 days instead of 6 days. So you work for 12 hours every day without overtime. From 6 in the morning to 6 in the afternoon for 4 days, and then you will have 3 rest days consecutive. So, and the other one is for those who are suffering from financial difficulties, yung tinatawag na reduced work week. Mas matindi yun kasi babawasan ang income ng workers doon because there will be less working days. For instance, only 3 working days at 8 hours, 24 hours ka na lang magtatrabaho. Pareho ng mga food companies, yung mga fast food. Maraming nagsasara na mga stores ngayon, mga franchises ng Jollibee, franchises, maraming nagsasara. Kasi dati dine-in, ang negosyo ng fast food, 80% dine-in, 20% lang yung delivery. Ngayon, nabaliktad na. 80% ng delivery, 20% ang dine-in. And hopefully tonight, the President will announce a new system para mag-umpisa tayo either Wednesday ng bagong sistema. Kasi we cannot afford to confine all the workers and then the government will be under obligation to give ayuda. That is not sustainable. Kasi trillions na ang utang natin sa World Bank, sa Asian Development Bank. At yan ay hindi naman masama masyado ang finances natin kasi maganda pa rin ang tingin ng mga International Monetary Fund sa atin because our fundamentals are very strong. Our economic team has laid the foundation of a very strong, kaya tumaas pa yung credit rating ng Pilipinas Kung gusto nating mangutang, pautangin pa rin tayo. But because of prudence and fiscal policies, dapat bawasan na natin ang government expense. At i-allow na nating bumalik ang negosyo para makarecover. But we are taking risk. That's why we have to observe protocols. Itong mga guidelines na ito is just an advice. No? Number 8 is just about for special non-working holiday, EDSA. It's not a regular holiday. No, it's not a regular holiday. So you do not pay 100% for people who are not working on that day because it's just a non-working holiday. So if workers do not work on that day, they do not get anything because that is no work, no pay. No? It's not a regular holiday. It's just a special non-working holiday. So dapat ibahin mo rin yung special day. Ang special day, yung Ninoy Aquino Day, that is August 21. Yung December 31 at saka November 1, tatlo yan eh. May pang-apat na ngayon, yung Immaculate Conception. So, pagka tumama ka dyan sa apat na special day ang tawag, pag pinagtrabaho mo ang tao dyan, 130%. 130%. Pero pag hindi nagtrabaho, walang pay because no work, no pay. Except yung mga monthly paid employees because they are considered paid for the whole month already. So it becomes relevant only for the daily paid workers. Number 6, final pay issuance. Ito yung maraming tanong sa akin. Sir, bakit ba, how long ba dapat namin ibigay yung last pay? Kaya nag-issue na ang Department of Labor dito kasi maraming nagre-reklamong mga empleyado. Bakit kayo mga employer, ang tagal ninyong magbayad ng last pay na nagkaka-clearance na yung tao, nag-submit na ng clearance, nag-turn over na ng kanilang mga documents, mga cellphone, mga accountability, na bigyan na sila ng clearance, bakit ayaw kayong magbigay ng Certificate of Employment at saka yung final pay? Ang deadline na binigay dito, merong deadline na binibigay ang DOLE dito sa kanyang advisory, although I said that this is just an advice, pero ang sabi dito 30 days. Yun din ang advice ko eh. The longest for you to withhold the money belonging to your employee is 30 days. Bakit ba wini-withhold ninyo? Iyan ay to assure na wala siyang utang, baka lalabas yung utang, huli na yung wala na tayong madidilakan. No? So, 30 days lang ang binibigay. Yung Certificate of Employment, 3 days lang. 3 days lang ang binibigay sa Certificate of Employment. Ngayon, may tanong. Sabi, Attorney, bigyan ba namin ng Certificate of Employment yung isang empleyadong walang hiya na bigla na lang nag-abandon ng trabaho niya, tapos nag-abroad. Tapos, after 1 year, galing sa abroad, babalik sa amin, manghingi ng Certificate of Employment. Bibigyan ba namin yan? Anong sagot ko? Sagot ko, bigyan mo. Pero ilagay mo sa Certificate of Employment niya na siya ay nag-abandon ng trabaho niya at hindi siya nag-resign. So, yung Certificate of Employment na comply mo na yung obligation mo under the law, you have complied because that is your duty to give. But you are not under obligation to tell a lie. Kung ang isang empleyado ay talagang walang respeto, bigla na lang mawawala, nag-abandon ng trabaho, tapos babalik after 1 year or after 6 months, kailangan niya ang Certificate of Employment. Bigyan mo. But you have to tell the truth. Kung siya ay tinanggal because of loss of trust and confidence, ilagay mo, this is to certify that Mr. Juan de la Cruz was connected with this company in the following capacity. Lagay mong capacity. From what date to up to what date? Sometime on August 25, 2019, he just left his job without informing management. So this is issued to attest to all the foregoing. Signed. Oh, ganun. Yan ba, masama ba yung sinasabi ko? Hindi masama yung nagsasabi ng totoo. Hindi ka nagsinungaling. At ikaw naman, na employer, pag may empleyado kang nawala, you have to write 2 letters to his last known address. Halimbawa, Attorney Pabros, meron tayong sales employee sa Pepsi, for instance, na dahil sa COVID, ay hindi na nag-report. Tapos tawagan mo, hindi na nagre-reply. Iti-text mo, hindi na rin nagre-reply. So, madali lang naman yan eh. Alam mo naman yan, gagawin natin. We have to send a letter to his last known address. Kung nagbago siyang address at hindi niya in-inform ang management, kasalanan niya yun. Dapat ilagay natin sa company policy natin na every January, dapat i-disclose ninyo kung nagbago kayo ng address, nagbago kayo ng marital status, nagbago kayo ng asawa, nadagdagan yung inyong beneficiary, para ma-update yung ating 201 file. And failure on your part to comply shall be considered a willful disobedience to a lawful order, which is insubordination, and maybe a ground for disciplinary action, not necessarily dismissal. So, ganun yun. So, pag ang tao ay nawala, dapat hanapin natin. Kung nawala na yung aso mo o ang pusa mo, ipapaalam mo sa barangay, ipapaalam mo sa homeowners association. Yung pang empleyado mo, nawala, wala kang ginawa. Katapos later on, magpapile ng illegal dismissal case yan. Tapos sasabihin mo, hindi ka naman tinanggal nag-abandon ka. So what is your evidence na nag-abandon siya? You have to establish the evidence by sending 2 consecutive letters. Sabihin mo, kung buhay ka pa, magpakita ka sa August 24 at 8 o'clock in the morning in the office of the General Manager, Miss L.B. Quezon. Halimbawa, merong isang empleyado ng hotel na bigla na lang nawala. Hindi mo alam kung anong nangyari sa kanya. We have to exercise due diligence as a good father of the company to locate an employee who is missing. Then, ipadala natin to by LBC or to go or whatever means para meron tayong proof na na-serve talaga sa last known address niya. Sabihin mo, kung buhay ka pa, magpakita ka sa August 24 at 8 o'clock in the morning in the office of General Manager Miss L.B. Sanchez Quezon. Kung patay ka na, huwag ka nang magpakita. Magparamdam ka na lang, no? Kasi hindi natin alam kung namatay na ba yan, ba't hindi nagpakita. So, pagka pinailang ka ng illegal dismissal, meron ka ng panangga na hinanap kita, hindi ka nagpakita. Ngayon na hindi nakita, hinahanap, nag-file ka ng kaso, illegal dismissal. So, on the first day of Sena, sa Sena pa lang, sa hearing pa lang, sabihin mo, Your Honor, we did not dismiss this complainant. As a matter of fact, I would like to put on record and to be reflected in the minutes that we are now giving him a memo telling him to report for work. Or in the presence of the arbiter or the hearing officer or the Sena officer, I want to make of record that there was no cutting off of relationship emanating from the employer. If he did cut off the relationship, it emanated from the employee. So ngayon, kung hindi siya bumalik, despite the fact that we have informed him formally, so siya ngayon ang nagdesisyon not to return to work. And therefore, this case of illegal dismissal should be dismissed for lack of merit. Ganun yun. Alam mo kasi, maraming abogado, gusto nila patagalin ang kaso. Bakit? The longer the case, mas marami silang makukobra sa kliyente nila. That is unfair. No? So, dapat sa una pa lang hearing, i-dismiss na yung kaso na yan para matapos na tayo at makapagtrabaho tayo ng productively. So, ladies and gentlemen, I have finished with the Dole Advisory. It's now 10:58 before 11. I will give you a very important topic. Baka kayo hindi ninyo ito in-expect, pero ito ino-offer ko ito kay Madam LB Sanchez Quezon dahil ito ay napakahalaga. Hindi ninyo alam na mamimiligro ang inyong mga empleyado, yung mga masususpect lang ng terorista. Tingnan nga ninyo yung mga mukha ng mga empleyado ninyo. Meron bang mukhang terorista dyan? No? So, how do we comply with law and at the same time protect our human rights? Alam nyo, mga kasama, in 1972, I was then a second-year student in the College of Law. I was the president of the Supreme Student Council. I was an active, very active student leader, an activist in Cebu. I organized a lot of rallies and demonstrations. And upon the declaration of Marcio, I was arrested and I was detained for 7 weeks without any warrant, without any charges, and therefore I have the experience of being confined. Although somehow I could not say that I was unhappy inside. Masaya naman kami doon dahil maraming mga kasama naming mga kolyala na taga Immaculada, taga Santa Teresa, at araw-araw kumakanta kami ng bayan ko at umiiyak kami at kami ay nag-spiritual prayer meeting pa sa loob. No? So maganda rin yung experience ko doon. Parang nagbabasa ako ng libro, nag-aaral ako sa loob, at mababait naman yung aming mga gwardiya. In fact, yung mga gwardiya namin na-indoctrinate na rin namin. Naniniwala na rin yung gwardiya sa pinapaniwalaan namin. So, ngayon, gusto kong i-share ito for you as managers and owners of business in Muntinlupa. How do you protect your if you have students, if you are in an academy, your faculty, your employees, you know, kaya lang naman itong batas na ito ay ginawa ng ating gobyerno. Dahil sa nangyari sa Lebanon, nangyari sa New York, nangyari sa Bali, Indonesia, nangyari sa Marawi, na 1,132 people died. Can you imagine? So, kung ginawa nila ito, paano natin maproteksyonan ang ating mga empleyado? So, ito yung definition ng terrorism. Pag binasa mo yung Republic Act 1147-9, ang definition ng terrorism is engaging in acts intended to cause death or serious bodily injury to any person or endangers any person. So kung hindi naman kayo gumawa ng ganito, bakit kayo matatakot sa anti-terror law? No? If you do not engage in acts intended to cause extensive damage to government facilities like highways, bridges, government buildings, mga establishment owned by the company, no? Engaging in acts intended to interfere with or destroy infrastructures like airports, no? Developing, manufacturing, and processing or transporting weapons of mass destruction. Yung mga gumagawa na ganito, yun ang dinidefine ng terrorist. You become a terrorist if you release substances that will cause fire or flood or conflagration, and the purpose is to intimidate the public. So, dapat sabihin mo, sir, bakit ba diniscuss mo ito? Eh kung isang empleyado mo naakusahan o ikaw mismo maakusahan ka for creating an atmosphere of fear or intimidation in the community by spreading false rumor. Kaya mag-ingat kayo sa pagpo-post nyo sa Facebook, no? Kasi baka magla-like kayo dyan, may magsasalita dyan na magsasabi daw na sunugin na yung PhilHealth. Pagka sinasabing ganun, tapos magla-like ka, you are endorsing an act of inciting to terrorism. So, kahit nag-like ka lang, maaaring mapoproblema ka, no? Kasi pinagmamasdan na ngayon ng Anti-Terrorism Council yung mga Facebook. Pinagmamasdan na yung mga pinopost ninyo. Kahit ang pinopost ninyo halimbawa ay sasabihin ninyo na dapat sunugin na yung PhilHealth or parusahan yan si Congressman Marcolita o si Congressman Defensor, yung mga ganon, kasi dinidipinsahan ninyong ABS. Baka matagurian kayong terrorist, no? So, ang act of terrorism is punishable by life imprisonment without pardon. Can you imagine that? You will be subjected to life imprisonment without pardon. And yung halimbawa, mananakot ka lang, tatakutin mo yung isang tao o isang opisina na bubombayin ko yung opisina ninyo, that act by itself is threatening to commit terrorism, is punishable by 12 years of imprisonment. 12 years of imprisonment, ha? Walang maximum, walang minimum, walang indeterminate sentence law yan. Yan ay isa lang ang penalty, 12 years imprisonment. Walang mitigating, walang aggravating, walang good faith. Kasi malum prohibitum ito. Good faith is not a defense. Kahit sasabihin mo, wala naman akong intensyon, kumbikto ka pa rin. Kumbikto ka pa rin kasi hindi naman ito mala prohibita ito. O itanong nyo kay Atty. Padros, kung hindi nyo naintindihan yung sinasabi ko. Any act of planning, training, or facilitating act of terrorism, training, planning, facilitating, life imprisonment without parole, inciting to commit terrorism. Yung bang mag-uusap lang kayo, tapos sasabihin mo sa kasama mo, kainuman mo, pare, bumbahin kaya natin yung PhilHealth, no? Eh, nag-i-incite ka na, nag-i-incite ka na ng terrorism noon, although nagbibiro ka lang. Kung merong napakinggan yun ng mga spy ng Anti-Terrorism Council, patay ka na. Proposal to commit terrorism, 12 years. Recruitment, nagre-recruit ka ng mga miyembro para magtayo ka ng terrorist organization, life imprisonment. Kita mo yan, ha? Penalty for publishing or advertising membership in a terrorist organization, life imprisonment. Kaya mag-ingat kayo na sumanib sa mga organisasyon, lalo na yung sa Facebook, merong nagtatayo diyan ng mga groups na anti-government, merong anti-Duterte, maaring wala kayong intensyon na magiging terrorist. Pero yung the manner that you are stating your anger on via social media may be misinterpreted at maaari kayong maaresto ng 24 days without charge. So yung mga foreign terrorists na nasa Pilipinas, they are just masquerading as employees or businessmen, pumupunta sa Pilipinas or preacher, pero talagang terrorist. Pareho nung nagpunta sa Tawi-Tawi na nilagyan ng dinamita yung katawan, pagkatapos pinasabog yung katedral. Pinasabog. Patay din siya. Those are suicide bombers. Kung mahuli mo yan na hindi pa siya namatay, life imprisonment siya. No? Yung nagbibigay ng suporta sa terrorist, life imprisonment din. Kaya mag-ingat kayo, magbibigay kayo ng suporta. Limbawa, nanghihingi sa inyo ng ayuda. Okay lang yung magbigay ng ayuda, lalo na sa panahon ng crisis. Pero yung binigyan ninyo, mga terorista pala yun. Nasa providing material support kayo, life imprisonment kayo, nagbigay nga lang kayo ng bigas. Kayo pa mabibilang ko, sabihin niyo, wala naman kaming intensyon. That is not a valid defense in a malum prohibitum. Yung nagtago or you destroy the instrument of the crime or you are assisting in the escape of a terrorist, accessory kayo, 12 years imprisonment kayo. Pero yung mga public official naman na umabuso sa kanilang kapangyarihan, nagpa-plant ng mga evidence, tanggal naman sila sa trabaho at saka sila naman ay mabibilanggo. And there are different ranges of imprisonment. Para ma-assure naman ang citizen na balanse ang batas na ito, yung mga pulis na umaabuso, sila ay mabibilanggo, matatanggal sa trabaho, mapurfit ang kanilang retirement, ma-cancel ang civil service eligibility, and magkaroon ng perpetual disqualification from holding public office, whether elective or appointed. Yung mga nag-i-intercept ng mga telephone calls na public official na walang authority from the court, 12 years imprisonment. So, ano-ano yung mga ino-oppose ngayon na there are more than 28 petitions pending before the Supreme Court. Ano-ano ba yung mga ino-oppose ng mga tao? Ito yun. Yung pag-create ng Anti-Terrorism Council. Yung Anti-Terrorism Council ay isang bagong agency na ang purpose lang nila ay maghahanap ng mga tao na terorista. At kung ikaw ay masususpected kang terorista, i-report ka sa ATC. ATC yung Anti-Terrorism Council, maaring maaresto ka without judicial warrant. And ang sabi ng gobyerno na kailangan na arestuhin ang tao without warrant dahil kung manghingi pa ng warrant of arrest, madidelay, maka-eskapo na yung suspect. So, there is a sense of urgency kasi pupunta ka sa court, mag-execute ka ng affidavit para manghingi ka ng warrant based on a just cause or unauthorized cause. Pwede mo siyang biglaan ng early retirement kung mabait naman itong empleyado na ito. Alam niyo mga kasama na nakikinig sa akin ngayon, ito, Kaya ako nananagalog kahit ako Bisaya para maintindihan niyo ako. Pag ang empleyado ay magaling, mabait, masunurin, siya nagkakaproblema, tulungan mo siya. Pero pag ang empleyado dati ng suwain, dati ng sinungaling, tamad, intrigero, panahon ng ganyang sitwasyon, huwag mong tulungan. At yan ang panahon na ang tadhana na ang nagparusa sa kanya. No? Kasi kahit ang Panginoon natin ay hindi tumutulong sa taong nagpapakasama. No? That is a choice. Choice niya yun Dapat tanggapin niya ang kanyang kapalaran. Mr. Marvin, paki-mute lang yung mga napapakinggan ko ha. Meron pa rin akong napapakinggan ng mga boses ng mga espiritu. May mga boses. May mga boses ng espiritu na naririnig ko No?
Sorry about that, sir.
So, what I'm saying is this, ladies and gentlemen. This is also in relation to the third topic, and I think I will forego with the third topic kasi wala na tayong panahon. Dapat pag 11:30 mag-question and answer na tayo. Nangako ako na may third topic pa na employee discipline. Wala na tayong panahon Anyway, hindi naman yan nakasali. Ino-offer ko lang, pero ngayon wala tayong panahon. Tatapusin ko na ito, malapit na tayong matapos para magkaroon tayo ng question and answer portion. Ang masabi ko lang ngayon is, if you are a good manager, you have to classify your people. A, B, C. A, B, C Ang A, yung mga angels. Attorney Pablos, sa Pepsi Cola, maraming angels. Ibig sabihin ng mga angels, yung mga tao na self-motivated, masisipag, tulad nila ni Bel Cardona. Yan ang mga talagang mga maasahan mo sa Pepsi Cola na mga matatagal na yan. Hindi pa ako isinilang, nandyan na yan si Bel Cardona sa Pepsi. At saka maaasahan mo. So, A, yung mga trustworthy, hardworking, dynamic, self-motivated, yan ang A. Yan ang alagaan mo kasi A. Yung mga C naman, ito yung C, kontrapelo. Ito yung mga tao na talagang pinadala ng masamang espiritu para gambalain ang buhay mo. Sila naggagawa ng problema, mga tamad, mga intrigero, mga reklamador, mga suwail, mga rebelde, yan ang mga C. Yung mga B, ito yung mga bali-bali lang, balibaliktad. Kung saan ang maganda, doon sila, papanig sila sa A, papanig sila sa C. So A, B, C profile, I have created that. I have written a book on that. Tony Pablos, I have written a book, yung The 8 Secrets for Success in Managing People. Sa book 1 yan, ang daming testimony about Pepsi Cola, the history of Pepsi Cola since 1990s. Nakalagay doon. Dapat mabigyan kita ng kopya pag nagkita tayo. Ngayon, kung hindi tayo nagkita, pabilhin mo na lang i-charge sa Pepsi. Kasi si Bel Cardona may kopyang ganun No? So, sa ABC profile na ganun, sa panahon ng kagipitan, yung A, alagaan mo. Pero yung mga C, bigyan mo na sila ng ito ng panahon na sila ang tadhana ng nagdesisyon sa kanila na mawawala sila kasi nahuli sila. Terrorist pala sila Paano natin tutulungan mga terrorist? Baka tayo makakasuhan pa tayo ng harboring terrorist. So we must have all the answers to the question so that when the time comes, may mga preventive action tayo and we should be very vigilant about people coming into our organization.
First question. Attorney, may COVID positive employee who is asymptomatic and advised by the doctor to undergo 14 days of home quarantine. The sick leave credits have previously been exhausted. Is the company obliged to compensate the 14 days of quarantine?
No, the company is not obliged. he will be on leave. He will be considered on leave without pay.
A follow-up question about COVID positive, 19 positive cases. Does the company submit a benefits claim to the ECC or the SSS, or the employee has to do it himself?
Well, the company should assist the employee because the SSS has an online submission procedure.
Can you repeat that, sir, please?
The company should assist the employee in submitting to the SSS through the online procedures.
Got it, sir.
Ako, ma-excel ako sumagot.
Direct to the point, sir. All right. Sir, going back to your anti-terror law discussion a while ago, again, from Ms. Joy Delis Guevara, what should we do if an employee or a manager is suspected to be affiliated with a terrorist organization?
Suspicion is just a suspicion. So, we will just take precaution because we cannot discipline an employee based on suspicion. If this person has been classified as A, classified siya as an angel, now he is suspected. But we have no reason to believe that he is so. Maybe he is only a victim of miscalculation or misperception. So we cannot make an action based on a mere suspicion. But we have to exercise extraordinary prudence in observing him, whether there is truth to the suspicion.
Okay. Ken, sir, kung suspicion pa lang, walang magagawa pa yung company.
Wala tayong magagawa kasi magkamali tayo eh. Any action based on suspicion will not be sustained as valid. Parang misis mo yan eh. Nasuspisuhan ka lang ng misis mo. Wala namang katibayan. Any action on the part of your wife would be impulsive. There must be enough proof or evidence to show that you are really guilty. Suspicion is not evidence.
Okay, sir. Siguro ang tanong na lang po nila is there anything, any step that they can take para to have the employee or the manager investigated on? Is there such a thing?
Hindi natin pwedeng imbestigahin. Ang gagawin dyan is to have a heart-to-heart talk with that person and to tell that person, Mr. Tumandao, we have received information about this. Wala kaming nakikita sa iyo, but now if you know something that we do not know, this is high time that you disclose to us, otherwise you will be putting the company in bad light. So, i-heart-to-heart talk natin siya at talagang umiiyak siya dahil hindi naman totoo at tayo naman ay naniniwala sa kanya. So, sabihin na lang natin na mag-ingat ka lang kasi otherwise, pag ito ay lumala, baka aristuhin ka sa loob ng kumpanya, which will embarrass the company in the community and also will put the company in a very bad light. No?
Got it, sir. Thank you so much. Sir, from Ms. Glenda Zamora Aninion, the head of the Public Employment Services Office of Muntinlupa City, Attorney Jimenez, please discuss the organizational justice a little more and the difference of ER, LR, and IR.
Magandang question yan. Thank you. I am very happy that somebody from government is the one asking it. First of all, ang ER is the preventive and proactive interventions undertaken by management. Pareho ng family day, family outing, sports activity, ginagawa ng Pepsi Cola, merong mga field trips sa mga executives nga, pumupunta pa sila sa ibang bansa. Pang PR ng management yan sa mga empleyado. That is ER, Employee Relations. Ang LR, ito yung medyo may problema na, like a grievance. Nag-file ng grievance, tapos nagharap yung management at yung empleyado. O, merong union, merong collective bargaining agreement, or merong pinipetition yung mga rank and file na isang supervisor o isang management na hindi makatao. So, hinaharap ng management. Yan ay LR group, yung grievance handling, tsaka yung nag-i-investigate ka ng empleyado, yung empleyado na sususpitsuhan na nagnakaw, ni-investigate mo, administrative investigation, LR yun. But the moment there is a summon from the Department of Labor, that is IR. The lawyer who handles a case, who files the position paper, who files the appeal, is called an IR lawyer. So, parang kuan yan parang metamorphosis yan, Marvin, from pupa, larva to caterpillar, no? Dadaan ka sa ER, LR, at saka IR. Doon sa San Miguel Corporation for 12 years, bago ako pumasok sa Pepsi Cola, ako yung overall director ng ER at saka LR. The moment na may kaso na, ibibigay na namin yan sa legal group ng San Miguel. Iba na yung mag-handle niyan. Pero pag nasa loob pa ng company at wala pa sa NLRC, ang mga LR group ang mag-a-assist sa mga different HR managers sa iba-ibang units ng San Miguel. Ganon yun. So, sa Pepsi Cola naman, dati meron silang LR doon na si John Padilla na umiikot sa iba-ibang mga planta, pero kada planta merong HR manager. Yung HR manager in charge siya sa ER. Pero pag LR na komplikado, may head office assistance na. Doon sa Visayas, Mindanao naman, si Attorney Sungkad, yun ang tumutulong sa mga planta. Ganon yun. ER, LR, at saka IR. Totality, ang tawag natin, organizational justice. Yun lang. Thank you.
Very malinaw po. Very malinaw. Very clear. Thank you so much, Attorney JBJ. Alright, next question from Maribel Theodores. Sir, because it's quarantine right now, lockdown, and syempre, we are lessening interaction, can email or courier service of notice of termination substitute for personal or registered mail, yung physical letter?
Napakagandang tanong yan. Alam mo ang sagot ko dyan, yes, but there is a requirement. You have to amend your company policy. Alam mo, Marvin, ang Supreme Court, ina-allow na ng Supreme Court ngayon ang hearing through virtual, no? Virtual hearing, pwede ngayon mag-investigate virtual hearing. Ang oath-taking nga ng mga abogado, through Zoom. So, yung sagot ko dyan, yes, pero ang bago yan magiging acceptable, kailangan i-amend mo ang policy mo at i-promulgate mo sa buong kumpanya, malaman ng tao na effective August 1 or effective ngayon 17 na tayo, effective September 1, we will adopt the following changes, no? Number 1, notice of specific charge can now be served through email. Anyway, we can track down the email, the thread, no? At mapoprobahan natin na marireceive talaga ng empleyado yun. So, my answer is yes, but with a condition.
So, babaguhin muna yung batas, ilalagay na ganun na pwedeng gawin yun bago gawin.
Yes.
Okay. All right. I want to be your student, Attorney JBJ.
You enroll in College of Law of San Beda, Alabama. No?
For free.
Oh.
Will I be a scholar?
I will appoint you as my assistant professor.
Thank you so much. All right. From Ms. Tez Valencia Navarro of the Muntinlupa City Public Information Office, how does the HR manage those employees falling under termination or reprimand? Anong sunod na hakbang for them? Or severance na ba talaga the relationship? Or pwede pa mag-extend ng tulong after? How do you navigate around that?
Dapat talaga merong due process kasi hindi tayo pwedeng ito yung formula legal dismissal or legal discipline equals just cause plus due process. So ang due process, ito lang simple, can you read that Mr. Marvin, can you see that? Written notice of specific charge. Nakita nyo?
Hindi ko, not on the screen, sir.
Siguro na kung ano yan. Anyway, my answer to that is just follow the job process protocol. First, you inform the employee of the charges against him. Second, subject him to investigation or written explanation. Yung tatlong step yan eh. Una, inform him in writing about the charges against him. Second is give him opportunity to be heard. That second part has two subparts, either written explanation or actual question and answer investigation, or both. Plus number 3, make a written decision after you have investigated him. So you cannot just issue a penalty without going through the 3 steps.
Sir, may follow-up question po ito. How does compassion play in a termination or a reprimand? Can an employee fight back kung feeling niya walang compassion yung pagka-terminate sa kanya?
Alam nyo, ang compassion, tama yun. Kung ang empleyado ay type A employee, for so many years he has been good to the company. All of a sudden, nagkamali siya. Error in judgment. Hindi niya sinadya. You should be compassionate to him. Huwag mo siyang tanggalin. Bigyan mo siya ng early retirement. Early retirement, ibig sabihin matatanggap niya yung 1 month for every year of service. No? Pero kung ang tao na yan ay winawalang hiya yung kumpanya at ninakawan ang kumpanya, then do not give him anything. He will go and forfeit his separation pay and retirement benefits. Kahit 20 years in service pa siya, ang matatanggap lang niya ay 13-month pay proportionate at saka yung encashment ng leave credits niya. That is for people who committed very serious fraud or misconduct against the company. Pero kung ang pagkakamali lang ay nagkamali ng diskarte na hindi naman sinadya at siya naman ay mabait na tao, be compassionate. So mamili ka na bigyan mo ng compassionate, huwag mong bigyan ng compassionate yung mga tao na sinasalahula yung company.
Got it, sir. Sir, next question from Ms. Daisy Iniego. Sir, a while ago you discussed about the labor advisory regarding the working conditions in the new normal, under the new normal. Sir, ang tanong po ni Ms. Daisy Iniego siguro is, meron bang specific implementing rules and regulation ang DOLE regarding work from home?
Ang answer ko, walang implementing rules at nagpasalamat akong walang implementing rules. Bakit? That means you are given the flexibility. Hindi lahat ng kilos mo ay ididikta ng mother-in-law. Dapat gumawa ka ng sarili mong diskarte. Huwag kang umasa ng implementing rules na specific. Ang ibig sabihin, pag hindi nagbigay ng specific rules ang gobyerno, binibigyan ka ng room for creativity to exercise your discretion. Kasi kung umaasa ka lang lagi ng detalyado na order ng DOLE, di wala na tayong sariling bait, wala na tayong sariling creativity. So, nasaan na yung management prerogative?
Sir, ang follow-up question niyo po, yung reduced working hours na ini-impose ng employer, so that's their prerogative now because there's no implementing rules.
Yes.
Right?
Yes, but you have to inform the DOLE about it. Ang importante dito ay hindi permission. You are not asking permission, you just inform them para ma-notify ang gobyerno na naghihirap ang kumpanya mo, walang operations. So paano mo bibigyan ng trabaho ng tao na walang operation? So, imbes na 100 people, you need 100, ito na lang, 20 na lang kailangan mo dahil ang volume ng negosyo mo. You have the right, but you have to choose at meron kang criteria sino yung pipiliin mo na bibigyan mo ng trabaho at sino yung no work, no pay. You must have a criteria. That's why you must have a very good record of your employee performance para mapipiliin mo kung sino ang mga dakila at sino ang mga baliw. Mamili ka ng empleyado kung sino ang mga dakila at sino ang mga baliw. Bakit mo patatrabahoin yung mga baliw? Isasabotage lang yung operation mo. Eh di, pipiliin mo yung, alam mo Marvin, kahit ang Panginoon natin, sa araw ng paghukom, isisiparit yung mga tupa sa mga kambing. So hindi masama yung ika-classify mo ang tao mo. May mga tao kang maasahan, kaya minsan sa bilang professor, merong sasabihin favorite ka ni sir. Eh bakit hindi mo maging favorite? Walang absent, laging nagsusubmit ng assignment, nagbo-volunteer pa ng erase the blackboard, sweep the floor. O eh di yun ang maging favorite mo. Yung mga masisipag, yun ang favorite mo. Yun ang sinasabi ko, no?
Sir, got it, sir. Thank you so much for that. Ms. LV Sanchez Quiazon, our president of PCCI Muntinlupa, has a question. Attorney JBJ, an employee daw po was afforded due process, and on the written notice of may written notice of charge, and based on the House Code of Discipline and based on our laws, talagang meron pong mga nalabag na batas and for termination. But upon the issuance of the letter, nag-beg yung employee to just be resigned. I-declare na lang siya na resign. And the COE, Certificate of Employment, was requested. Are employers allowed or can employers put the details of the violations on a Certificate of Employment?
Well, sa first question mo na, will you accept the resignation of a person who is found guilty of an offense? That is where you exercise compassion. Miss LB, kung yung tao na yan ay type A, angel mo yan, ay bigyan mo ng compassion, so bigyan mo siya ng graceful exit. Pero kung walang hiya yung tao na yan, sinasalahola yung hotel, sinisiraan pa yung management, eh bigyan mo ng certificate of employment na ibibigay mo yung katotohanan. At hindi yan illegal. It's not illegal to state the truth. Walang batas na nagsasabi na magsinungaling ka. Lahat ng batas ay dapat magsasabi tayo ng totoo. Totoo naman talagang na-found guilty siya. Eh bakit hindi natin sasabihin sa Certificate of Employment na gano'n? Lagi na lang tayong naaawa sa mga taong hindi karapat-dapat na kaawaan. So hindi siya nagbabago. So you are not helping him because if he transfer to another hotel, ganon din ang gagawin niya at siya ay manloloko. So tayong lahat ng mga HR, magtulungan tayo at i-identify na natin yung mga dakila at ang mga baliw. Yung mga baliw ay bibigyan na natin ng certificate ng pagkabaliw. No?
that's a new thing that I learned today. Pwede pala po yun because usually certificate of employments are just yung length of tenure, yung sinahod, ganyan. So pwede palang ilagay specific.
Alam mo, Marvin, nung ako ay nasa Pepsi Cola, bibigay ako ng Certificate of Employment. Meron kaming empleyado na 40 years in service. 40 years in service. Napakagaling na empleyado. Alam mo ang Certificate of Employment ko? 12 pages. 12 pages. Bakit? Parang transcript of record, Marvin. Nilalagay ko, nag-umpisa siya as an ordinary casual worker. Tapos every year, na-increase yung sahod niya, na taas yung kanyang rango, nakalagay sa Certificate of Employment niya. At yan ay pinaprain niya, proud siya sa kanyang mga apo dahil yun nakalagay doon ang mga laurels, yung how he rose from the organization. Isa lang ang employer niya sa buong buhay niya, Pepsi Cola lang. Kaya tinatawag siyang Mr. Pepsi Cola. If the closure is based on financial difficulties, the separation pay is 1/2 month for every year of service. But in a decision written by the Supreme Court in the case of Capital Wireless versus Secretary Confessor, 1/2 month is interpreted as 22.5 days because 15 days plus 5 days service incentive leave, that is 20 days, plus 2.5 days gotten from 1/12 of the 13-month pay is 2.5 days. So that is 22.5 days salary for every year of service ang matatanggap ng bawat empleyado. Tax-free.
Wow, tax-free. So again, 22.5 days per year of service.
Yes.
Tax-free. Thank you so much, sir. Follow question. Sir, is the company required to provide or pay for the quarantine facility of COVID-19 positive employees?
The quarantine facilities should be shouldered by the local government unit, not the employer.
Pag wala na po quarantine facility government use na, iba wala po.
Well, there is no law that compels the employer to pay. So the employee must find a way, but if the employer wants to help, that is not a legal obligation, but just a moral obligation.
It's the prerogative of the company. Kung magbibigay or hindi.
Marami kasing gustong magbigay, kulang naman sa means, no? So, if you compel the employer to do that, wala namang legal basis yan at saka unfair din naman sa management yan. Hindi naman natin ginusto ang lahat na ito, no?
Sir, from June to Henko, what is the difference between mandate and advisory?
The mandate has the effect of a law. Ang mandate, pag hindi ka sumunod, may penalty. Ang advisory ay mahihiya ka lang na hindi mo siya pinagbigyan sa kanyang advice. Para ba, Marvin, na sinabi sa iyo ng nanay mo, Marvin, ang advice ko sa iyo, mamili ka ng babae na matangkad para tumaas yung lahi natin. Advice lang yun. No? Pero pag sinabi ng batas na huwag mong pakasalan yung pinsang buo mo kasi bawal yan, that is a mandate of law. Maging null and void yung marriage mo. O, di ba? Iba yung advice sa mandate eh.
Got it, sir. Thank you. Sir, you asked for a participant to ask this question a while ago, and somebody actually asked from Joy De Les Guevara. Sir, so what if the military or the cybercrime group or authorities visit your company to arrest the individual of being suspected as terrorist?
Well, my advice is that you have to have a lawyer with you, and you have to have a conference with the arresting officer, and to give respect to management and not to put the company in a bad light, to give utmost confidentiality do not announce to the whole company that one employee has been arrested. It should be done with utmost confidentiality because there is no evidence yet that he is guilty. So, ating katungkulan natin na proteksyonan natin ang tao natin without being suspected of harboring a terrorist. At yun namang mga militar, pag sila ay mga professional, hindi naman yan mga bastos eh. They will also respect us. Pero mas maganda talaga, Marvin, kung meron kang abogadong kasama kasi matatakot sila eh, yung militar, matatakot silang mag-abuso. Pag may abogado eh, kahit uupo lang yung abogado, hindi magsasalita. Iba ang impact ng abogado eh.
So support the employee within the bounds of laws.
Yes.
Got it. Thank you, sir. Sir, sabi niyo kanina regarding advisory and mandate. Sir, Maria Erica Aquino regarding labor advisory number 26, telling employers to shoulder the testing of employees. Is it okay for employers not to follow this advisory?
First of all, Erica, kinlarify na yan kaninang umaga na it is applicable only tong mga symptomatic. Yung mga symptomatic lang, hindi lahat ng empleyado. At ang aking sagot dyan, you follow that if you can afford. But if you cannot afford, you just tell the Dolly that we cannot afford. Sa PhilHealth na natin yan i-charge. Total, maraming pinamimigay na bilyones ang PhilHealth. Dapat ngayon magamit na natin yung kinocontribute natin sa PhilHealth. No?
Pero nasan nga po yung bilyones ng PhilHealth?
Nandyan na, malapit na yung makikita kasi hindi yan makaka-eskapo kay Congressman Marcolita at saka Congressman Defensor. Bukas, babalik na naman yung investigation sa Senado bukas. Manood kayo. No.
Attorney JBJ from Ms. Tez Navarro, again of PIO. Sir, marami po ngayong nagsisell online, di po ba? Paano po pag government employee, minamanage yung sarili niyang Facebook account, nagsisell siya during her free time, pag Saturdays, Sundays, ng kanyang goods. Is it ground for double compensation?
Hindi yan ground for double compensation. Alam mo, Ms. Navarro, intindihin mo rin yung mga empleyado na naghihirap. Hindi naman nagnanakaw yan. Imbes na pareho ng taga-PhilHealth na ang nanakawin yung pera ng gobyerno, naghahanap sila ng paraan para ma-augment yung income nila. So, you should be more compassionate. At yan naman ay ginagawa nila Saturday na hindi during office hours, ay gumawa ka lang ng policy, papirmahan mo kay Mayor Presnedi na kailangan in doing that, you should not compromise yung trabaho nyo, walang conflict of interest. Baka merong naglalakad ng papel dyan sa munisipyo, tapos sasabihin, unahin ko yung papel mo basta ikaw ay bumili ng aking pinagbibiling mask. Ayan ang conflict of interest. Yun ang dapat nating pangalagaan. Pero alam nyo, ang parents ko were very poor public school teachers. And during weekend, my mother nagbebenta ng mga mosquito net at blanket. Yung pamilya namin, gumagawa kami ng tableya. Yung tableya galing sa kakao at binibenta namin yon kasi hindi nga enough yung sahod sa gobyerno. So walang conflict of interest doon. In fact, we should admire these people who are trying to do their best to survive in a very difficult situation.
It's very commendable.
Yeah.
Sir, anonymous question. may health protocols naman yung company, pero require yung employees to go to the office. Now, an employee, by going to the office and on the relegation of his duties, contracted COVID-19, sino pong magsha-shoulder ng hospitality?
Okay, paki-mute lang yung naririnig mo ba yung mga naririnig ko?
We're gonna mute, sir.
Okay. Okay. Pinapunta sa office. Tapos doon sa office first of all, dapat i-verify natin yung allegation. Sa office ba talaga niya nakuha yun? No, madali lang kasing sabihin na sa office ko nakuha yung sakit na yan eh. How do you prove that? Ano ang percentage ng time mo sa office at sa bahay? You can never tell because the COVID is invisible. The virus is invisible. That is just an allegation that he got that from the office. Assuming na it is true na napatunayan talagang sa office kasi meron talagang positive sa office, ay di ang employer dapat tumulong dyan at mag-shoulder ng cost. Kasi whatever happen in your company, responsibilidad mo yun. Ang problema lang nitong tanong na ito is the premise, whether mapatunayan talaga niya na sa office niya nakuha yun. No?
Got it, sir. So, iko-contest mo muna na kung nakuha mo nga sa office mo
Oo.
bago i-shoulder ng company.
Saan ka ba nagtatrabaho, Marvin?
I mean, yung question po ito ng participant natin, sir.
Hindi, ikaw, where are you connected?
Well, I'm a freelance events host, sir. So, I'm out and about.
So pagka may ikakasal kong anak, pwede kang kukunin as
Pwede po, sir.
yeah, masaya ka kasing kausap eh. Bunin ko yung number mo from Miss LB.
Yes, please. I would be very glad to be of service to you, sir. Sir, next question from Ms. Stacy again. Until when can we place employees under forced leave as part of the flexible work arrangement as issued by the Department of Labor and Employment? Is 2 months ECQ counted?
Okay. Ang forced leave, ang maximum sa regular employee is 6 months. Sa mga contractual, yung agency, 3 months. So, included na yung lockdown. So, after leave without pay for 6 months, Marvin, after that, you have to decide whether to continue employing him or to give him separation pay by retrenchment or redundancy. So parang relasyon ng mag-boyfriend niya na nag-call off muna sila ng 6 months, Marvin. After 6 months, magdesisyon na sila kung ituloy pa ba natin ito o putulin na natin para makamove on na tayo. Kailangan may closure para makamove on.
Sir, so counted yung 2 months na is?
Yes. Counted yun.
Okay po, sir. Sir, anonymous question. If a company reduced the salaries of employees by 25%, kasi pwede naman daw yon, sabi ng labor advisory, isn't that in violation of diminution of benefits of the labor code?
Yan.
The attorney JBJ, in times of conflict, labor code will prevail. Can EES file a complaint against the labor code violation?
Ang ganda ng tanong na yan. Kung sino man yung nagtanong na yan, anonymous, napakatalino yan. Kasi ang ibig sabihin niya ng non-diminution ay nasa Article 100 yan sa Book 3 ng Labor Code. Na ang general rule, Marvin, you cannot reduce the salary of your employee. Bawal na bawal yan. Pati yung mga benepisyo, hindi mo pwedeng i-withdraw yun. No? But there is an exception, and that exception has been approved by the Supreme Court in the case of Insular Hotel Davao Waterfront versus NLRC. And the Supreme Court said that there's nothing wrong in the reduction of salary if it is agreed upon. Take note ha,
agreed upon by the parties. It is not imposed by management on the employee. Agreed upon. Halimbawa, Marvin, sabihin ng boss mo, Marvin, gusto man kitang i-retain pero wala na talaga akong means to pay you. So, ibigyan na kita ng separation pay for your year of service. Ang sabi ni Marvin, Sir, huwag mo lang akong tanggalin, pwede mo akong bawasan ng sahod, basta huwag mo akong tanggalin kasi kailangan kong trabaho. And then they agree. They put that in writing. That is not null and void. So, reduction of salary as a general rule cannot be done because of the principle of non-diminution. But exception if it is agreed upon by the parties, as merong kabayaran para hindi ka matanggal, no? So, that is allowed as an exception. Pero yung tanong niya, kung dinidakan lang siya ng 25% na hindi naman at tinanong siya kung agree siya, pwede siyang mag-file ng kaso niyan, no?
Sir, this is a very handy knowledge because I have so many friends with reduced salaries during this pandemic, and I understand from the perspective of the employers that there are losses in the company. So it should be agreed upon.
Yes.
The company cannot just say na, okay, babawasan po kayo lahat.
Yes.
Got it. Okay, thank you so much for that. That was very useful.
Kasi
Okay, sir.
Marvin, ito just to elucidate, ang employer-employer relations kasi is a bilateral contract. In other words, bilateral means you and I agree. So, I cannot change the terms and conditions of our contract alone, unilaterally. I have to get your consent.
Got it, sir. Thank you so much for that. Sir, from Billy Harding. Sir, so ang industry daw nila ay healthcare industry. Pero may employees na ayaw pumasok na ang ginagamit ay RA 11058. Ano raw po ang safe way to send a two-way rule notice to the employee who refused to render their duty?
Ang gagamitin natin ay Article 297 ng Labor Code, willful disobedience to a lawful order given by superior in relation to work. Article 297, Book 6 of the Labor Code, paragraph B, no? Willful disobedience yan.
Sinasabi ng employee na kayo naman, lumalabag naman yung kumpanya sa RA 11058, an act strengthening compliance with occupational safety.
Well, that is another issue. If you can prove that we are guilty, then we will be fined. Pero ikaw, if we prove you guilty, you will be dismissed because that is insubordination. So pareho tayong guilty. Hindi ibig sabihin na pag guilty kami, hindi ka na guilty, no? So pag ikaw empleyado ka, huwag mong gamitin na may violation ako na reason na hindi ka sumunod sa instruction ng management because it is your duty to follow the instruction of management as long as the instruction is reasonable and it is in relation to your work.
So at any point, the company is safe to send a two-way rule notice?
Yes. Yes.
Sir, from Patricia Tumala, for our warehouse team, they lift heavy items. Pwede po ba silang hindi gumamit ng face shield because magiging cause of accident?
Well, there must be a way. The engineers can devise a way. The lifting of heavy item is not an excuse because compulsory yung paggamit ng mask. Between the work and the safety of the worker, the first priority is safety.
Sir, got it, sir, understood. From Maricor Angulo, sir, yung admin hearing, paano mag-a-apply yung due process protocol?
yung admin hearing.
Yes, sir.
First of all, you amend your policy. Sinabi ko na kanina you can serve your notice through email, then your investigation can be done through Zoom. Now, kung siya ay walang means to do the Zoom, bigyan mo ng pera para magkaroon siya ng Zoom. No? Or i-charge mo sa kanyang 13-month pay yung pambayad ng Zoom. Basta merong Zoom, ihatid mo sa bahay, ito, hindi ka makapunta, you are not required to be physically present, but you can have it through Zoom. No? You can, pag merong gustong gawin talaga, Marvin, may paraan. Pag ayaw mong gawin, maraming dahilan. So, the management can create innovative ways to implement that. No?
Got it, sir. Sir, to clarify lang daw po from Ms. Tess Navarro of Matalupa PIO, hindi raw po siya yung hindi compassionate na employer. yung
Hindi naman.
nagkakata without compassion. Hindi
I was not referring to him. I was not referring to her. In general ba? In general.
Yes, yes, yes.
General.
Yes, and I can attest, Ms. Tess Navarro is a very compassionate employer. Sir, for, all right. Sir Nicky Gonzalez, about the anti-terror law, let us say that a minor posted something against the government. Is it possible for the minor to be arrested? Or are they exempted from the anti-terror law?
Well, there should be a clarification of minor, because if you are below 12 years old, you cannot be guilty of any crime, no? Pero pag above 12 ka na but below 18, meron na yung liability. So you have to clarify the age, what age. Kaya alam mo, Marvin, doon sa drugs, yung mga minor ginagawang courier. Kasi pag nahuli ng pulis, hindi makakasuhan dahil minor. Halimbawa, 7 years old, uutusan ng drug pusher na ihatid yung drugs. Pag nahuli yung bata, hindi mo yan makakasuhan. But she can be a witness. She can be a witness if the child is arrested with the parental guidance. That child can be a witness for the state. Naging state witness siya against doon sa nag-utos sa kanya.
Got it, sir. Thank you, po. Sir, anonymous question as well. This person worked for more than 2 years as HR, and there was so much work to do. Hindi na niya kailangan trabaho, pinapatrabaho pa rin sa kanya. And the company was not paying overtime, no salary increase for 2 years. Dapat ba may separation pay pa rin ba siya? And also, ayaw pa rin ibigay yung employment certificate niya. What can she do?
Pumunta siya sa DOLE kasi ipapatawag yung employer na yan. Kawawa naman, HR na nga siya pa yung nabiktima. So, how can a healer be a healer if he is the one wounded? Yan ang tawag niyan, Marvin, is the wounded healer. So, pumunta kayo sa DOLE kasi ipapatawag yung employer ninyo. Kasi yung employer ninyo siguro is not knowledgeable of basic labor law. At saka may mga employer talaga, Marvin, na walang puso. Na parang pag nag-hire ng tao, parang siya ang nagmamay-ari ng tao na wala nang karapatan yung tao niya. So dapat yan, isumbong mo sa DOLE.
Thank you for that. Sir, from Reynaldo Chua, what is the probationary period for teachers? Is it 3 years under the DepEd Manual of Regulations?
Yes, teachers, especially the teachers in the higher education, 3 consecutive years. Not just 3 years, 3 consecutive years. That means 6 semesters or 9 trimesters. And hindi lang gano'n, Marvin. Yung 3 taon na yan, kailangan ang kanyang performance evaluation is satisfactory. And kailangan full load siya para magiging tinatawag na tenured ako. I was the only one tenured professor of law in UE for 20 years. Kasi lahat sila mga part-timer, ako full-time ako while I was working with San Miguel Corporation. At night, I was teaching. So, dumaan din ako ng 3 years probationary period kasi the Manual of Regulation for Private Schools is supplementary to the Labor Code in terms of probationary employment for the teaching personnel. Pero yung mga non-teaching, 6 months pa rin yung kanilang probationary period.
Got it, sir. Thank you. Sir, from Nikki Gonzalez, can an employer terminate an employee who has been on sick leave for more than a month now? Is that possible?
First of all, Marvin, with due respect, I will correct the English. You cannot terminate an employee. That is murder. You terminate the employment. You terminate the employment, you terminate the services, but do not terminate the employee. No? Huwag kayo magkamali sa English ninyo. Your English may be hazardous to your career. No? So, yan maraming nagkakamali niyan, pati ang Supreme Court sinasabing the employee is terminated. No, you cannot terminate a person that is murder. Magiging terminator ka.
Again, I learned something new today because I would usually say terminate an employee.
Terminate an employment. No? So, my answer is no, you cannot terminate an employee who is on leave for one month. Because that is not one of the grounds for termination under Article 297. You have to prove that he did not file a leave of absence para maging absence without official leave siya. And you have gone through the gradual process of penalty. Hindi naman that absences is not a very serious offense that calls for immediate termination of employment. It should pass through suspension first, then if repeated, termination. You cannot go to termination immediately without passing through warning, reprimand, warning, then suspension. There are 3 kinds of suspension: light suspension, less grave suspension, and grave suspension until termination. That is called progressive penalties.
Got it, sir. Thank you. Sir, anonymous question. Sir, if regular employees can be temporarily laid off for 6 months and contractual employees for 3 months, how about po yung pregnant women who are high risk during the pandemic and cannot do work from home setup because of the nature of work? Gaano po katagal ang allowable no work, no pay arrangement?
Walang problema ang mga pregnant kasi meron silang nakalaan na 105 days na maternity leave, no? So, yung sa pregnancy pa lang, sa hindi pa lang nagpanganak, you can put her in a work from home arrangement. At the law is silent on maximum. If you want to be lenient to her, you give her until she delivers a baby. As long as he will produce output, no? Because there is no advisory about pregnant women, but the law is very protective for women and for pregnant women, no? So in this country, we have the longest maternity leave in the whole ASEAN. We have 105 days, and if you are a solo parent, you add 15 days, so that is 130 days. Plus another 30 days without pay. So that is 120 30 plus another 30 days. So that is very long for pregnancy. And then second even pasa, kung may pasa load tayo, merong pasa leave. Ipapasa niya yung 7 days sa husband niya. So even if the husband is working in another company, mag-a-arrange yung dalawang HR na ipapasa ng wife yung leave ng husband, magsama yung wife and husband. Pagbalik ng wife, pregnant na naman siya.
Got it, sir. Thank you so much. Sir, can the management be accused of unfair labor practice if active union organizers were included in the forced leave?
Well, they were included not because they are union official. And tandaan lang ninyo ito na just because you are a union official, you are not exempted from company policy. The company policy still applies to union official. So, hindi gagamitin ang pagka-union para hindi sila ma-included, no? So, if everybody is included, whether you are union official or not, it's okay. It's not an unfair labor practice because hindi sila tina-target para lang talaga sila lang. Walang discrimination eh. So, walang ULP dyan, walang unfair labor practice dyan.
Nikki's saying sorry for the wrong grammar. No need to be sorry, Nikki. Filipinos are guilty of that. We all use that. I use terminating employee as well, so no need for that.
Okay, alam mo, Nikki,
Attorney Jimenez to correct all of us.
alam mo, Nikki, kahit ang justices ng Supreme Court nagkakamali. Mga justices na yan, ha?
Sir, what is the meaning of, from Patricia Tumala, what is the meaning of economic priority workers and special concern area in the joint memorandum circular of DTI and DOL?
Ang economic priority ay yung engage in food delivery and manufacturing because food, ang pangalawa yung medical services kasi nasa pandemic tayo. Yun ang pangatlo yung nasa power generation, water at yung transportation for movement of goods. Yun lang, tatlo.
Sir, one of the last two questions. Sir, from Anonymous Dopo. After consuming all sick leave, emergency leave, and of a regular staff was forced to go on leave without pay due to high salary. Up to how long can the person stand the forced leave? Is 6 months start? Does the 6 months start from the date he started leave without any pay, or from the beginning of lockdown sometime in March?
From the time of the leave without pay, 6 months.
Okay po. Sir, pwede ba gumindi ang isang employee because ang work niya dun sa company ay collector?
Well, ang paghindi niya ay hindi based on health and safety. Walang ebidensya na pag ginawa niya yung trabaho niya ay nai-expose siya in addition, yung bang additional exposure to health and safety hazards. So, hindi yan reason. And dapat, lalo na starting tomorrow or Wednesday, babalik na tayo sa GCQ eh. So, wala nang reason wala nang validity yung reason na yan. Kasi, ang buhay talaga, Marvin, lahat tayo exposed tayo sa hazard, sa risk. Wala talagang safe. Kahit nga ikaw nasa bahay lang, pag merong nagdi-deliver sa'yo, yung delivery pala ay siya ang carrier. So walang assurance, wala talagang complete assurance. So ang buhay ng tao, everyday we take risk. Kung gamitin natin yan as a reason not to obey our superior, dapat mag-resign na tayo para mapalitan tayo ng tao na susunod. Maghanap na lang tayo ng trabaho, nasa bahay lang tayo. No? Ganon lang ang buhay. It's a choice. Always choices. And you accept the consequences.
Thank you so much. Sir, from Tony Aguilar. Sir, the DOLE is encouraging employees to hire people with disabilities and yung mga senior citizens. Pero paano po sila ngayon? Ngayong lockdown, pwede mo sila humindi sa work because they're compromised or they're easily susceptible to.
Yeah. In fact, ang mga employer talagang ini-encourage. In fact, may tax deductibility yan eh, yung at least meron kang 10% of your workforce are PWD, no? In decision making, pag namili ka ng taong work from home, unahin mo talaga yung PWD, yung seniors, at saka yung pregnant women. Yung tatlo na yan, although yung trabaho nila dati, hindi naman pwedeng trabahoin sa bahay, bigyan mo ngayon ng another kind of work, like i-update mo yung 201 file. Ang mga HR, kailangan mag-isip kayo ng mga bagong trabaho na hindi natin napagtuunan ng pansin in the past. No? Yun lang 201 file, hindi pa na-update. Kailangan trabahoin natin during lockdown. Kaya ako, sinabi ko kay Miss Delia kanina na during the lockdown, I was able to finish 6 books. Nakasulat ako ng 5 libro na publish.
Yung 6 books, sir, paano nyo naman ginawa yun, sir, ng lockdown?
Meron ako mga estudyante na sila ang encoder. Binabayaran ko ng 1,000 pesos a day, encoder. At kami lang yung mag-i-edit ng anak ko. Meron ding researcher. Bibigyan ko ng research. Kasi ang sabi ko sa mga estudyante ko, tutulungan ko kayo kumita, pero magtrabaho kayo. Saan kayo kikita ng 1,000 pesos a day? Pero meron akong quota sa kanila. They have to finish a certain number of pages in coding. So, nasa diskarte yan eh. Ha?
1,000 per day ba? Pwede po ako.
Mas malaking kita mo as an event organizer. No?
Sir, last question na lang po ito. Before we move on, last question na lang po. Sir, legal po ba, from J. Montague says, legal po ba nabawasan ng transportation allowance because work from home?
Well, kung ang policy ninyo malinaw, alam niyo yung mga tanong na yan, ang ibig sabihin, ang policy nila is not clear. Your policy should include a provision that you need transportation allowance because you need to come to the office. Now that you do not have to come to the office, the rationale for the allowance does not exist. So it can be taken away. It does not constitute a diminution of benefit.